Okay, I think we can slowly start this lecture. I would first would like to welcome everyone to this lecture in the series of Sustainable Global Economic Law lectures. And I'm particularly happy to welcome Lorenzo Cotula, who is our today's speakers. I would not talk a lot. I will briefly introduce Lorenzo and will give him the floor immediately. So just a brief introduction. Lorenzo Cotula is a principal researcher at the International Institute for Environment and Development, where he leads research, policy engagement, and field-level projects on the legal arenas where natural resources governance meets the global economy. Basically, Lorenzo's research is situated in the intersection of natural resource governance and global economic law, and particularly investment law. And I personally found Lorenzo's research very interesting and compelling because it's always empirically very rich, very richly empirically grounded. And it shows in the research itself, this work together with communities sometimes also takes the direction of action research. For today's lecture, he will be talking on property rights and property law, actually how different property legal regimes or ideas or concepts are shaping different kinds of not only economic but also all kinds of social relations in the global political economy. We have an hour and a half for the entire event, and Lorenzo will be speaking for around 40 minutes, and then we have equally as much time, around 40 minutes for Q&A and for a discussion. So without further ado, Lorenzo, please, you can start your talk, and we will have the discussion afterwards. So please go ahead.
Thank you very much, Vladimir, and thank you to the whole SGEL team for the very kind invitation. I'm delighted to be here. I'm delighted to discuss together a few ideas. I'm not here today to present a paper as such, rather I will reflect in brainstorming mode, and I'm here to learn as much as I'm to share. And the topic I'd like to explore is what I called in the title for the session as the shifting contours of property. And I guess the underlying question that I've been exploring that underlies that title is how today's social and environmental challenges raise issues about the rights, limitations, and obligations that attach to the very concept of property. So as Vladimir rightly pointed out, a lot of the work I do is very applied. Today, I'm really hoping to do some slightly more conceptual reflections really based on that wider work. And to illustrate the problem I would like to explore, consider, for example, the issue of extreme concentrations of wealth that exist today globally and also within specific polities at the national level, which have prompted calls for redistributive action and where the concern is not only often the skewed distribution of material assets, but also inequalities in the rights, limitations, and obligations that are applicable to different actors and the resulting impacts that these different configurations of rights and obligations have for the distribution of power within society. Consider also the issue of climate change and biodiversity loss, which are pressing environmental challenges today, and that often require rebalancing property protection and environmental regulation, and also more fundamentally moving away from a paradigm of appropriation whereby humans appropriate nature towards the notion of environmental stewardship and responsibility. Now, in the work I do that on a day-to-day basis, which is very much at the interface between research and practice, I've come across these issues over and over again in the context of large-scale projects, for example, agribusiness plantations, mines, infrastructure projects, where on the one hand, the projects have compounded the policy imperative to secure the rights of politically, socially, juridically marginalized groups, for example, the rights to land, to territory, to voice and representation in decision making. But they have also raised fundamental questions about the rights the companies acquire, stopping biodiversity loss where projects intervene in forest intensive areas requires halting the allocations of land to new commercial projects, but also limiting the rights that companies have within their existing land holdings, or regulating, creating a balance or regulating the balance between the rights the company have to operate and also the limits that they need to respect in order to comply with certain environmental regulations. Also, conflicts around large-scale projects often hinge on obligations that the companies have or should have towards the environment, towards people affected by their operations, or towards society at large. And also the projects often expose fundamental imbalances that exist in the rights and obligations of different actors. So for example, where international treaties on foreign investment establish generous protections for the land rights of business foreign investors over and above national law, while affirming no commensurate obligations on the one hand, and on the other hand, where groups that are affected by the implementation of the projects may see laws limit their own rights or subject those rights to stringent obligations that effectively erode the rights from within, such as, for example, in many jurisdictions, the obligation for people to show, to demonstrate that they're using the land productively, where notions of productivity systematically marginalize or undermine the claims of shifting cultivators, pastoralists, hunter-gatherers, etc., etc. So I'm very interested in this notion of the interplay between rights, limitations, and obligations because of the way I've observed emerge from these real life settings, and also because I think it prompts really interesting, from a scholarly perspective, questions about the interface between different legal regimes that are often observed or studied in isolation, depending on the situation. Exploring these issues may interrogate anything from a constitutional property clause to national legislation on land and natural resources, all the way to international treaties protecting foreign investment, protecting human rights, protecting the environment. Now, the topic is evidently very vast. What I like to focus on today to illustrate the issue is one particular legal notion, the notion of the social function of property. It's a legal concept that has emerged over the years, has been codified in some national constitutions, and now, I will argue, is under pressure from developments occurring, particularly under international law. And I would like to, I hope that tracing the evolutions concerning this particular concept can illustrate how stratifications of lawmaking set the scene for tensions that can arise between different legal instruments that are inspired to different policy objectives, different philosophical underpinnings. I would also hope to illustrate how this type of contestation can affect the relationship between private and public interests and how legal regimes deal with that relationship, and also raise the question of whether responding effectively to today's social and environmental challenges requires us to give a new thought to how we piece together the different rights, limits, and obligations that are attached to property. Now, what I would like to cover is four main points. One, what social function is, the concept itself, how it historically emerged, and how it's been, in a sense, codified in some national constitutions. Two, what the practical implications are, just drawing on some examples of how courts, government agencies have applied the concept. Three, tensions that arise or that have arisen more recently in the application of this concept, particularly with regards to the articulation between national and international law. And then finally, a few concluding remarks on what next, where does this take us in terms of paths going forward. I should, before I start, highlight a big caveat, which is that obviously we're dealing with extremely diverse settings, particularly when it comes to discussing issues that are inherently linked to national jurisdictions, which are, of course, extremely diverse. I'm not here to provide exhaustive coverage of the topic, but rather just to highlight a few examples that I hope in brainstorming mode will illustrate the issues and hopefully prompt some good discussion after my initial presentation. So starting from the first point, what social function is, I think if we look at sort of doctrinal mythologies that have emerged over the years, property has often been imagined as an absolute right. I think in the 18th century, William Blackstone famously captured in the words defining property as the sole and despotic dominion over things, right? So a very extreme, a very absolute notion of property as an absolute right. Nowadays, I would argue that most jurists would recognize that rights have limitations and come with obligations, and that notions of property and regulation are not antithetical, but actually property is produced by regulation, which governs the establishment, allocation, enforcement of rights, as well as setting limitations and obligations that emanate from the fact of holding a right. Right. So the contours of property are actually historically determined rather than absolute in philosophical terms, and they also evolve over time. And if we observe what's been happening in different jurisdictions, in the way they've been looking at property, it's very much a reflection of that. Now, legislation very often restricts what owners can do. For example, they restrict owners from adopting conduct that can produce adverse impacts on neighbors, on third parties, or public interests, such as the environment. Or they require, laws require owners to minimize those impacts by taking proactive measures. So the environmental regulation, the field of environmental regulation very much functions in those ways. American jurist Joseph Singer noted that when we look at this type of limitations and obligations attached to property, we quite often frame them as exceptions. The quote I had here is, when ownership rights are limited, we imagine those rights to be exception, those limits to be exceptions to the general rule that owners can do whatever they want with their property, right? So there is this notion that there is an absolute notion still there of property, which is then limited through effective interventions by legislators. But I think what Joseph Singer and many other jurists have argued for over the years is that in fact there can also be more fundamental limits of property, whereby allocating and protecting property is inherently linked to and therefore qualified by the pursuit of certain public interests. And I think one interesting example of that approach is what Léon Duguy, a French jurist in the early 1900s, called the social function of property. According to Léon Duguy, who, while being French, was at the time speaking in Buenos Aires as part of a cycle of seminars he was giving, he was saying property doesn't serve private interest alone, it serves a public interest, and therefore the legal contours of property should be shaped by the fulfillment of that public interest. In that conception, in the notion of what he calls social function of property, then limits and obligations are not exceptional and specifically legislated occurrences, but actually part and parcel of what property means in the first place, right? So property is inherently a bundle of rights, a bundle of limitations, and a bundle of obligations. Now, these are ideas, but ideas over time found their way into actual positive law. Over the years, a number of national constitutions have linked property to the notion of social function. This is the case particularly of some countries in Europe and some countries in Latin America. Examples include Article 42 of Italy's 1948 constitution, which links property and the protection of property to pursuit of its realization of or fulfillment of its social function, and also Article 58 of Colombia's 1991 constitution. And in the Colombian case, the constitution refers both to the social function of property and also to the ecological function of property. So this notion that there are inherent limits that are not just social in nature, but also have an ecological dimension. Now, this Colombia and Italy are two examples. There are more, but what these constitutional property clauses have in common is that they very often emerge in the context of major political change and also of sustained demand for some form of redistributive reform, redistributive action to deal with what were perceived to be, by some, at least in the political spectrum, as fundamentally unjust distributive setups. And in those situations, in those constitutional negotiations, then the coupling of the notion of private property, the recognition of private property with the pursuit of certain public interests reflect a compromise between different political forces and different conceptions of property. What is interesting to note is that the idea or ideas connected to social function have also emerged in countries that where the constitution per se does not affirm the social function of property explicitly, but that also present those characteristics of major political transitions occurring and there being redistributive imperatives of some sort, an example being South Africa, where a number of jurists have talked about social function in the absence of specific or explicit constitutional hooks. So this is, in a nutshell, by way of very, very, very broad brush remarks, what social function means and where it came from and how it found its way in some national constitutions. Now, what does that mean in practice? What are the practical implications of a constitution affirming that property is linked to the social function? Well, first of all, let's see what it doesn't entail, what it doesn't mean. While limiting property, and the notion of social function also provides a form of legitimation for property, right? So it links the existence of property to there being a public interest. And as such, it doesn't fundamentally question the place of property in the economic system. It doesn't fundamentally question the role that property plays in encoding, as Katharina Pistos put it in the Code of Capital in her book, in encoding the legal foundations of the capitalist system. That since the Industrial Revolution, for example, has driven climate change and sort of carbon emissions in the first place. It doesn't, recognizing a social function, doesn't necessarily acknowledge the violence and dispossession that underpin the historical development of property law, including in the context of colonialism, of racial domination. I'm thinking here of the work of scholars such as Brenna Bandar, for example, and several others. And also, unlike so-called rights of nature approaches that are grounded in indigenous knowledge and indigenous paradigms, the social function of property very much reinforces an anthropocentric perspective whereby humans appropriate nature, right? Which is really the foundational principle that has facilitated extractive activities over the past few decades. But what the social function of property does, and albeit subject to different contexts and different interpretations, etc., is that it tends to qualify or enable legislators and courts to qualify the protection of acquired rights and potentially enables significant compressions of those rights for a public interest if certain conditions are met. For example, depending on the situation, public authorities have relied on social function clauses to justify public action in wide-ranging areas such as land use planning, housing regulations, and diverse forms of agrarian reform. And very often these measures were inspired by two principles of social justice, often with mixed results, it must be said, sort of slow implementation of land redistribution programs, for example, in some settings, unintended consequences of measures meant to regulate agrarian contracts in favor of tenants, etc., etc. But sort of there has certainly been extensive use in some jurisdictions of the notion of social function in that way. In Italy, the notion of social function has also been provided a hook for authorities to consider public interest criteria when determining compensation for expropriation. The Italian Constitutional Court over the years has had evolving jurisprudence. It's changed, the approach has changed, particularly over the past 10 years, has changed a lot compared to earlier jurisprudence. But in a nutshell, the principle that still holds in that context is that while compensation has to be reasonably related to market value, compensation payment could, in certain circumstances, be less than full market value. Certain public interest justifies so, and the reason, the arguments brought to justify that is very much this notion of property being linked to performing a social function. Now, the social function presents ecological dimensions too, and I mentioned that in Colombia, the Constitutional Property Clause explicitly recognizes that ecological dimension or the ecological function, and the Constitutional Court in Colombia has also looked at the notion of social function in a number of cases. One of them, which was in which the court primarily referred to social function in relation to freedom of enterprise, which is a separate right than the right to property, but nonetheless, the notion is still the notion of social function nonetheless provides an interesting hook there. So in a recent case in 2016, there was a complex dispute involving mining in fragile mountain ecosystem known as the Paramo. And over time, regulations changed, including in response to public mobilization on the part of some of the people living in the area. And at some point, the government enacted some measures that were excluded mining in that particular ecosystem, but with the exception made for existing mining projects. And the Constitutional Court, in its judgment, struck down that exemption, and in its justification, its reasoning, the court recalled the notion of social function, which qualifies the right of freedom of enterprise under the Colombian Constitution, and it noted that the Paramos as an ecosystem warranted protection because of their being a carbon sink, a biodiversity hotspot, and a source of water for much of Colombia's population. So the notion of social function was used, at least in part, by the Constitutional Court to justify certain compressions on the rights of, in that case, mining companies. So to sum up, in terms of the application, it's a huge field, but what I would like to convey here for the purpose of this conversation is that we're looking at very diverse policy areas, that we're looking at engagement with the notion of social function by legislators, by government agencies, by courts, particularly constitutional courts. And also what I like to highlight is how the notion of social function can create opportunities for public action that is aimed at addressing social or environmental issues, even though the outcomes are not necessarily very effective or the most effective or as effective as the initiators would hope them to be. So what I would like to do now is to bring the international law dimension into the picture. So far, I've been really focusing on the concepts, I've been focusing on constitutional law and jurisprudence, but how does international law come into play? Well, the broad notion of social function leaves significant scope for diverging views, right? On which considerations, which interests to prioritize, right? So it's a very broad notion, and the interpretation of that notion can therefore be subject to evolution by courts, by government agencies, evolutions originating from shifts in public perceptions, in public policies, in terms of what is deemed to be the most conducive or promising or appropriate solution in a particular context, but they can also arise from the interplays between constitutional property clauses on the one hand and other legal instruments on the other. Now that is true even within a given domestic legal system. In Italy, for example, I mentioned the Constitutional Property Clause, which came into force in 1948, just a few years earlier. Italy had a new civil code, and the civil code included a definition of property that in many ways is more linked to the more conventional or classic liberal property theory than it is to notion of social function, therefore creating then complexities in how the interplay between different instruments pans out in actual interpretations and applications of the law. Within the domestic legal sphere, there is a hierarchy of norms whereby constitutional provisions will then inform the interpretation of ordinary legislation. But the focus for me today is really on the interface between constitutional property clauses on the one hand and international law on the other. And various branches of international law are relevant here. I mentioned earlier the evolutions in Italy's constitutional courts, jurisprudence on compensation for expropriation, and the fact that particularly the past 15 years or so, the court has placed greater emphasis on there being a need for a reasonable relationship between the market value of an asset and compensation for expropriation. And that evolution compared to what the court had mentioned earlier, where in the 80s, for example, in 1980s, the courts didn't strike down as unconstitutional certain provisions of Italy's legislation, even though they were resulting in compensation payments of 30% of market value further reduced by taxation. And the shift that occurred from the 80s and 90s to the 2000s in the jurisprudence in the constitutional jurisprudence in Italy owes much to the dialectic between the Constitutional Court in Italy on the one hand and the European Court of Human Rights on the other, which in a number of judgments heavily critiqued the system in Italy, including the Scordino case in 2006, decided by the Grand Chamber of the European Court of Human Rights. So the interplay between the dialectic, if you will, between domestic jurisprudence and international jurisprudence has resulted in a shift in the way in which the notion of social function is interpreted and applied in Italy as regards expropriation and compensation in particular. But more interesting for me, for me to explore is the interface between the notion of social function on the one hand and the rise of international investment treaties and arbitration on the other. The rise of these treaties and the rise of international investment dispute arrangements has raised new questions in my mind about the contours of social function and ultimately the contours of property itself. Now, I should say very clearly that international investment treaties protect foreign investment, right, and property. They don't usually adopt the language of rights. Rather, they create obligations between states to adhere to certain standards of treatment with regards to each other's investors. But by providing broad definitions of investment, by setting standards of treatment for that investment, by providing access to legal remedies internationally, the treaties do influence the protection and boundaries of corporate property. For example, on questions as to whether public regulation interferes with foreign investors' rights or legitimate expectations to such an extent that that regulation must be accompanied by payment of compensation and also according to what standards. Now, it's going to be a little bit broad brush again. Please forgive me for that. And I look forward to discussing more in the discussion part. But the treaties, on the one hand, take very broad, very diverse formulations. The current system hinges on a vast network of bilateral and regional treaties, and each treaty is a little bit different in its own ways. But by and large, investment protection is at center stage. Most treaties are really about protecting foreign investment, and concerns that broad standards of protection could make it more difficult for states to act in the public interest have prompted some treaty recalibrations of the year. For example, the introductions of certain environmental exceptions or the reaffirmation of the so-called principle of the right to regulate. But most treaties do not really feature the sort of inherent and more encompassing qualifications that really stem from notions such as social function. If one looks at expropriation clauses, they typically link compensation to commercial value alone, so even beyond the jurisprudence of the European Court of Human Rights, which has referred to a reasonable relationship between the two parameters. Arbitral tribunals have excluded that public interests such as environmental protection could justify reduction in compensation payments, for example. A growing minority of investment treaties establish or refer to certain types of investor responsibilities, adherence to standards of CSR, corporate social responsibility, and responsible business conduct, but they often do that through non-mandatory clauses, and very few treaties establish actual investor obligations towards those affected by the investments or to protect the environment. Interestingly, states with constitutional social function clauses have also signed treaties that omit references to social function. So since the year 2000, the expropriation clauses in most of Italy's bilateral investment treaties do feature some reference to restrictions arising from domestic law or courts. But in operational terms, the expropriation clauses set similar parameters to those of any other investment treaties, for example, linking compensation to market value. Now, why does this matter? It matters because, in my mind, these evolutions in constitutional law on the one hand and international law, including international investment law on the other, they reflect different and potentially conflicting approaches to reconciling public and private interest as regards to addressing complex social and environmental challenges. Federico Suarez, a Colombian jurist, for example, noted that several arbitrations that are currently pending against Colombia under international investment treaties partly arose from decisions of the Constitutional Court, including 3 cases related to environmental restrictions in the Paramo. So you might remember I mentioned earlier that the Constitutional Court had justified those restrictions partly on the grounds of social function. In one of those 3 cases, a split tribunal recently found that measures to protect the Paramo did not, or the relevant Paramo did not constitute expropriation, but they involved inconsistent state action, and as such, they breached the minimum standard of treatment under the applicable trade agreement between Canada and Colombia. This is a very complex case. I would like to refer anybody interested in it to a recent commentary written by Jimena Sierra, who was commenting on the arbitral tribunal decision. And also there was a webinar organized by the IEL Collective, the International Economic Law Collective, that very much looked at different aspects of the tribunal's decision. But the broad general point I would like to make here is that there are conceptual tensions between different ways of conceiving of property and different ways of reconciling public and private interest, and that these tensions are finding their way not just into domestic law cases under constitutional courts, for example, but also into international legal disputes. And that these different tensions partly arise from the different nature of the instruments at play. I mentioned how in the case of constitutional provisions, they often reflect a hard fought, hard negotiated settlement between different political forces within a particular polity at a key political transition, whereas investment treaties are concluded between states and sometimes or often when it comes to particularly relations between global north and global south states in the context of unequal negotiating power between the parties, often also informed by the diffusion, the circulation of model clauses or treaty clauses between different contracting parties more than by constitutional provisions and developments within each of the state parties themselves. So the outcome of this is that the social function clauses that we have in constitutions remain, they are there, but their application and interpretation has come under increased international law scrutiny. And I would say that has happened at a time when global social and environmental imperatives would arguably call for further clarifying rather than diluting limitations and obligations that are applicable to commercial activities. And that leads me to the final part of the reflection, which is where next? Where do we go with this? And I was interested recently in rereading a statement that Alexis de Tocqueville made back in 1847. That was on the eve of the revolutions that shook Europe in 1848. And he commented, property will be the great battlefield. Now, for him, he was witnessing a major shift in the long shadow of the French Revolution, the demise that was cementing the demise of the aristocratic order in France at the time, and also a reconfiguration of property from feudal to capitalist constructs. Yeah? And he was observing that in the context where there was a strong connection between property and citizenship. In France until 1848, political participation was limited, was hinged on wealth. Yeah? The suffrage, the ability to vote, was only restricted to a small minority of wealthier groups. And so Tocqueville expected political contestation to increasingly hinge, to increasingly play out between the haves and the have-nots, and to increasingly hinge on not just who owns what, but also, in the way he put it, more or less profound modifications of the right of owners. Yeah. So, and it's interesting what was happening then with a major shift in the way property itself was constructed, driven by fundamental change in political and economic organization, to reflect on that today where the context is so different, but many major social and environmental and economic challenges still hinge on renegotiating or rethinking aspects of property. Consider, for example, the issue of fossil fuel phase outs, how the modalities of those phase outs, the cost allocation, who pays for what, what sort of compensation, if any, would fossil fuel companies be owed for the phase out. Yeah, and I think that sort of question raises issues about property, not just in the sense of whose rights are protected and how, and also moral questions or political or policy questions of whether it's fair or not for certain companies to be compensated and according to what standards, but also in very practical terms, whether the way property is conceived of, for example, the extent to which fossil fuel companies are owed compensation and whether that compensation is attached to market value alone and how that is calculated, whether the prospect of expensive legal claims can make it more difficult for states then to take social and environmental measures that might be needed, for example, from a climate change perspective or from other perspectives as well, in terms of biodiversity loss, et cetera, et cetera. And so the question is not just who controls what, but also who has what say, what leverage in public decisions when you have, for example, contested debates between, for example, carbon intensive industries on the one hand and environmental advocates on the other, right? So in my mind, there is some good thinking to be done there around these notions of the limitations and obligations of are connected, as well as the rights connected to property. And there are also more fundamental questions about the continued relevance of the property paradigm itself, knowing or recognizing that that has historically been associated with an ecologically destructive economic model, and the need or the value of learning rather from indigenous conceptions that frame the relationship between humans and nature, not in terms of property, but in terms of stewardship and interdependence. So I will leave it as a question for us to discuss together as to with the challenges that we face today in terms of climate change and social inequalities, whether we are then, as Tocqueville was back in the 19th century, witnessing a moment where we are faced or asked or called to reflect or rethink or redesign the way in which we conceive of property, including its limits and the obligations that are attached to it. So thank you very much. I hope to I look forward to your own not only questions but also comments and contributions, because I hope that at least some of what I said resonated in some way with the topics and themes that you're looking at in your own research. Thank you.